Okay, so I'm going to take a big sip of water so my voice doesn't just run out. And we're going to start topic 2, which is the promotion and enforcement of human rights. Okay, so as I said, this is what we're going to be looking at from the syllabus. So in particular, we're going to look at in the international community. Remember, as I said, what is a state? A state is an independent country, defined territory with a permanent population and an effective government. Okay, so that's the idea of a state, almost synonymous with country. What is sovereignty? It's the power to make your own decisions without external interference. So, state sovereignty means that international law is unable to interfere with what happens within a state without the state's consent. All right. So, the UN Charter strengthened the existing international system based on the sovereign equality of the states so as to protect states from unwanted violent intervention from antagonistic external forces and, by extension, protect the human rights of citizens. Okay, so this is an idea that makes state sovereignty good. Okay, particularly that this idea of antagonistic states can't just declare war left, right, and center when they feel that they need to protect the citizens' human rights. Oftentimes they don't even want to protect human rights if they have ulterior motives. But nonetheless, that's something that was good about this idea of state sovereignty that was outlined in the UN Charter. Okay, however, as evidence, sovereign states are also determining the process and the nature of the implementation or non-implementation of human rights. So basically, state sovereignty empowers states to breach human rights and to not protect human rights. An idea that I want to just quickly capture here is that just because a state has legislation protecting a human right doesn't necessarily mean that it's protecting the human right. That might sound a bit confusing, but let me explain. So let's say I live in country X. Country X has a law on every single human right. But let's say I'm a citizen of country X and I go to the government and say, hey, I was forced into slavery for 2 years. And then the government says to me, okay, whatever. Does that mean that that country or that state has actually protected my right or my freedom from slavery? No. Okay, so just because a country has human right legislation or legislation protecting human rights doesn't actually mean they're protecting human rights. How do we actually know that a state is protecting human rights then? Compliance. Are they complying to their own domestic legislation and international obligations from the treaties they've ratified? Okay, and in the case of Australia, ratified and enacted. So things like R versus Wei Tang tell us that Australia is compliant to the Commonwealth Criminal Code Section 270, okay? Because they were quick to sentence Wei Tang and quick to send out the message that no, Australia will not tolerate cases of slavery and the breaches of freedom from slavery, okay? Which tells us that for slavery, Australia is pretty compliant, okay? All right. So, state sovereignty creates major issues when human rights breaches occur, okay? Because it's almost like they can just kind of do what they want. And the external international committee can't really do anything about it. The fundamental principle of international law is that no nation state can interfere in the domestic affairs of another nation state unless authorized by the UN. So this is under the responsibility to protect, okay? That we have a responsibility to protect our own citizens, but also the citizens of other states. However, the UN has experienced extreme weakness in enforcing its decisions on human rights due to state sovereignty and veto power, as I said. And the example there is what I was talking about earlier, veto powers specifically that were used by Russia and China in Syria. One way to promote human rights is to automatically make international law domestic law, as they do in Belgium, France, Germany, and Austria. So as soon as international law is signed and ratified, immediately becomes a part of domestic law. The Netherlands has gone one step further, having international treaties ratified into their constitution, which is, of course, good. Okay, so areas of effectiveness and ineffectiveness for state sovereignty. Firstly, states can exercise influence in international forums. Okay, this means that if a state chooses to use state sovereignty for good, because remember, state sovereignty isn't always a bad thing. For example, Australia uses state sovereignty for good to protect human rights. It uses their ability to govern their own people to protect those human rights. And this can influence the wider international community to also protect those human rights. States can impose sanctions on other states for breaches of human rights. So this was seen particularly in the Russian-Ukrainian conflict. When Russia chose to go into Ukraine, invade Ukraine, a lot of states, including Australia, sanctioned particular trades with Russia as kind of a sign to stop, or in a way to punish them. So if a state is starting a war with another state, the surrounding states can choose to not trade with them as a kind of punishment. States can implement domestic laws protecting human rights, as I said, and that's really good, obviously, for the people. However, states can ignore international human rights. States can enact discriminatory laws and engage in repressive practices. States can remove existing domestic human rights protections, and states can ignore domestic human rights violations. Yeah, effectively, state sovereignty either gives states the power to be really good or be really bad. Gives them the power to do whatever they would like, okay? So another kind of practice question that you can do to start getting you thinking is this one here. When it comes to human rights, is state sovereignty beneficial, or has it proved to be more of a hindrance? Discuss. What do we think? Okay, so the United Nations now. The United Nations is the world's largest and most widely recognized intergovernmental organization. Not to be confused with an NGO, okay, a non-governmental organization. Remember, it's an IGO, meaning intergovernmental, different governments are coming together to work together. It is a chief organization involved with international law, as we kind of have figured out by now. As I said, it was established under the UN Charter 1945, and it was comprised of several UN organs, including General Assembly. So the General Assembly is like the Parliament of Nations, right? It's the image of the UN that we all have, that big room where they all kind of come meet together and sit together and vote and discuss particular human rights breaches and issues. It has 193 members. It consists of representatives from all member states with equal voting power. It's the main forum for international discussions, deliberations, declarations, and recommendations relating to human rights, as I said. Each member has only one vote. Now, that has been criticized because people think should states with a population of 1 million have the same or equal value of their vote to states with, billions of people? Should they only have one vote each, or should, you have one vote per 10 million people you have in your population? Equal voting power in international discussions, declarations, and recommendations, okay? The good of that is that, there's equal voting power. So that means that marginalized or often, marginalized states or states that aren't as powerful or dominant as others aren't kind of quieted by more powerful and dominant states, okay? All right, so the responsibility to protect. For those of you who are doing World Order, you will look at this in greater detail in that elective, but this is kind of an introduction to it, and for everyone else, we still need to know this principle. So, the responsibility to protect forefronts the protection of human rights as an integral part of responsibility that goes with being a sovereign state. It has 3 pillars. Firstly, that states' responsibility to protect their population from international crimes. Secondly, that it's the state's responsibility to assist other states to build their own capacity to protect human rights. And thirdly, the responsibility to take action when a state has failed to protect their population. Okay, so If Australia is not protecting our human rights, other states carry the onus or carry the responsibility to protect our human rights. For example, in Syria, the US invaded in 2003 as ISIS was accused of countless human rights breaches, and the Syrian government weren't acting against it, so the UN, under the responsibility to protect, invaded Syria. Okay, we also have the Security Council, which is another organ or part of the UN. It has 15 members, 5 are permanent: US, UK, China, Russia, and France. Yes, okay, there are 5 there. Sorry, I was thinking, did I only put 4? 5. 10 other countries elected for 2-year tenures. So on a cycle of 2 years, Australia might be a part of the Security Council, and then someone else is voted in. It's charged with the preservation of international peace and security. It exercises its power through legally binding resolutions and can authorize military sanctions, actions, or peacekeeping operations. The 5 permanent members have the power to veto decisions, so say, nope, this is not happening. And if they vote no, it's not going ahead, and they have the power to send peacekeepers. Okay, so if the other 10 members say no, that doesn't necessarily mean that the decision's not going ahead. That will only be the case if they have a majority no vote, but if everyone else says yes, and then China, for example, says no, it's not going ahead. They have veto power. Okay, there's also the UN Secretariat, which provides the various information, studies, tasks, and facilities needed by the UN. So it's doing all the kind of information gathering. And then we also have the International Court of Justice, or the ICJ, which has it's the UN's primary judicial organ. It has jurisdiction under the UN Charter to settle international disputes submitted to it by member states and produce advisory opinions on matters of international law. Okay, so basically Australia versus Japan, as I was talking about before, they would have come to the ICJ for settlement regarding whaling in Australian waters. Yeah, as it mentions there. Okay, and then we also have the UN Human Rights Council. Its main purpose is to promote and protect human rights by investigating and exposing human rights breaches, and then producing reports and recommendations. So a good example of this is annually it releases reports on retentionist states. What's a retentionist state? A state that still uses capital punishment or the death penalty. Okay, so it produces reports on the amount of times that they use the death penalty in that state. So China in 2020, I believe, used the death penalty over 1,000 times. Okay, and that was reported in the UN Human Rights Council report for that year. Why does it do this? Well, the aim of naming and shaming. Okay, it kind of follows the idea that if you name and shame a state for its use of capital punishment, the state will be more likely to prohibit the use of capital punishment domestically. Is this the case with China? Probably not, because China does not really care. It uses the most cases of capital punishment globally. Nonetheless, the UN Human Rights Council has 47 members that are elected by the General Assembly. It allows for a procedure for complaints by individuals with breached human rights. It conducts reviews of the human rights situation in all 193 member states. An advisory committee provides expertise and advice. It has been condemned unlawful. Ban Ki-moon, 2007, says that all victims of human rights abuses should be able to look to the Human Rights Council as a forum and springboard for action. Yeah, so it's designed as an organ, a springboard for action, to actually materialize change for human rights. Australia is a member, yet countries are critical of Australia's election due to inhumane treatments of refugees, as I was saying, in detention centres, at-sea incarceration rates, homelessness, and our strict terrorism laws. Okay, so the United Nations, its areas of effectiveness and ineffectiveness. Okay, you need to know this. Firstly, it's effective because it's kind of published the International Bill of Rights, right? UN Charter, ICCPR, ICSCR, UDHR, right? This has then catapulted into the publication of other treaties that have protected other human rights, or have been more specific on particular human rights, which again is a really massive thing, because think about how many states have been influenced by these treaties, have actually enacted these legislations into their own domestic legislation. Then we have the UN Summit 2005, which introduced the responsibility to protect doctrine, which is a really massive thing and really helps with protecting human rights and responding to human rights breaches. We also have the promotion of environmental rights, which is becoming increasingly more important, such as we saw in the Paris Agreement that we spoke about earlier. The UN Millennium Development Goals as well. So the UN, those are kind of the areas of effectiveness. The biggest area of effectiveness is, I would argue, the Bill of Rights. Could also talk about peacekeeping missions as well. There's an array of things to talk about. Areas of ineffectiveness though. Certain countries that are signatories to the UN continue to dispute the notion of human rights and believe it is up to the state to decide on the rights of their people, such as China. Okay. Veto power has also been criticized because it regularly stands in the way of aims of the UN summit. Okay. As I said, Syrian conflict, the UN wanted to do something about it. China and Russia vetoed that decision. Nothing was done. The powers of the P5, all with nuclear weapons. So there we're talking about, again, China, Russia, France, England, and the US. In the UN Security Council go unchecked. Okay, so because they have veto power, there's no one kind of checking them and performing those checks and balances. And again, it's been critiqued for being Eurocentric, okay? The UN, has been critiqued for being Eurocentric and not considering non-European ideas of human rights and protecting human rights. Okay, so intergovernmental organizations now, moving to the next dot point. 1 and 2, I don't know why it says 1 and 1, but the two that you can look at are the UN and the Commonwealth of Nations. Those are kind of the two biggest ones. There are others, of course, but Commonwealth of Nations we're going to look at. The UN, we already looked at, of course, we just spent time looking at. So if you were asked about intergovernmental organization, I would probably go for the UN because we've just spent so much time about it and you look at it in such great detail. But we can also look at the Commonwealth of Nations. It has 54 members, okay? It operates within the framework outlined in the Singapore Declaration of Commonwealth Principles, which is cooperating in the common interests of their peoples and in the promotion of international understanding and world peace, okay? So those are the aims of the Commonwealth of Nations. Its stated aims include the promotion of democracy, the rule of law, human rights, individual liberty, and good governance. Okay, another intergovernmental organization. All right, so the Commonwealth of Nations is second only to the UN in terms of its diversity, global renown, and longevity. It brings a wide range of worldviews and understandings that help to piece together what is fundamentally a universal right, and it's heightening its openness and transparency amongst the global community. Okay, so we can also look at the Commonwealth of Nations. Okay, we can also look at the African Union as another IGO, which has 55 member states. It launched in 2002. It has the Constitutive Act of the African Union, which sets out the aims of the African Union. The two largest, not all of them, but the two largest being that it encourages international cooperation, it promotes peace, security, and stability on the continent, okay? It has attempted to address the prevalence of child soldiers in Africa. For those of you who may have looked at that as your contemporary issues, you would be aware of kind of just the predominance of that issue in Africa, unfortunately. They have condemned Gaddafi's rule in Libya and supported the 1970 resolution of no-fly zone due to his crimes against humanity. Okay, so the African Union is another IGO that you can look at. Another one is the Arab League, which was founded in 1945. It has 22 members, okay, so not quite as large as, obviously not the UN, the Commonwealth or African Union, but Syria's membership has been suspended since 2011. Its main goal is to draw closer the relations between member states and coordinate collaboration between them. Economic sanctions have isolated Assad's regime due to human rights breaches. Okay, so these are kind of an array of intergovernmental organizations that you can look at. Now, would I say to only look at the UN? No, because I have seen questions where they specifically state will specifically ask you to look at an IGO that's not the UN. So it's important that you know of at least one that's not the UN. Okay, now looking at courts and tribunals in the international community. Let's have a look at the International Court of Justice. As I said, it's an organ of the UN. Australia versus Japan, 2010, I want to say, is an example of a case. Basically, it hears legal disputes between nation states, okay? It defines and interprets international conventions. State sovereignty means parties are not obliged to comply with the ruling, okay, which is perhaps its biggest limitation. Japan didn't have to stop, okay? Japan has state sovereignty. Japan doesn't necessarily have to agree with what the ICJ says. It has limited jurisdiction. Another massive limitation is this next idea. It requires the consent of state parties to hear matters. So Australia and Japan had to consent to actually having the case, like being involved in the case in the ICJ, which you can see is a pretty big limitation, because how frequently does someone want to be on trial and will consent to that trial? So it requires a significant degree of accountability from the states. They're unable to hear cases brought by individuals or by private organizations. Okay, it's between states. Okay, International Criminal Court now. The International Criminal Court has jurisdiction over crimes against the international community. Okay, so the way I remember the International Court of Justice and differentiate it from the International Criminal Court is the ICJ. We'll start with the ICC. The ICC, I think criminal court, okay, crime. And then I think, okay, transnational crime, no, crimes against the international community. Okay, I relate it to the dot points in crime. Think about your international crime dot point in the crime module unit. Think about the types of crime, transnational crime, no, crimes against the international community. So then I think, okay, if that one's against the international community, then this one is the one that deals with disputes between states. Okay, so let's look at the ICC. The ICC has jurisdiction over crimes against the international community, as I said. So these include things like genocide and war crimes. It was created by the Rome Statute of 1998, which was ratified in 2002 in Australia under the International Criminal Court Act 2002 Commonwealth. The case must have been either referred by the UN Security Council or allegedly committed in a territory of an ICC member state. Now, this next idea I really want to hone in on. It is a court of last resort, okay? It will only hear cases if the nation state investigating the crime is not genuine or is unwilling to do so, or they do not have the resources to do so. So, slavery is a crime against the international community. Okay, we know that. So then why wasn't Wei Tang tried in the International Criminal Court? Well, she wasn't tried in the International Criminal Court because Australia was able to respond. Australia was able to try her and punish her. Okay, so the ICC will only do its thing when the domestic response hasn't been suffice or there has been no domestic response. Okay, so only 118 nations have both signed and ratified the Rome Statute. USA and Syria are among the countries who have not. Now, if you have not signed and ratified the Rome Statute, the ICC can't try people who commit crimes against the international community in those states. So, for example, President Assad cannot be brought to stand trial. Russia has veto power as well, okay, which can prohibit Russia being tried at the ICC. The biggest critique for the ICC is that it's expensive. Its annual budget is only $100 million, okay? But you'll see that to get convictions, it will way blow over that. So for example, Forbes in 2014 reported that in 12 years, they spent 1 billion, okay, which is much higher than the annual budget. I know that's for 12 years, but even still, that's much higher than the annual budget, particularly for only 2 convictions, okay? $1 billion is, very, very expensive, very slow as well. The biggest critique is that it's resource inefficient. It's slow, it's very costly. So whilst it is resource efficient and its convictions are few and far between, the ICC is still an important mechanism for its effectiveness at protecting and raising regard for human rights at the international level. But I would still say that it's very ineffective because it's very costly and very slow. Now, Thomas Lubanga, 2012, is an example of a case you can refer to for the ICC. He was found guilty of conscripting child soldiers in the Congo and sentenced to 14 years imprisonment. Okay, we also have ad hoc tribunals. What does ad hoc mean? Well, it means for this purpose. So the tribunals are set up for particular purposes, okay? So we had an ad hoc tribunal for the former Yugoslavia. We had an ad hoc tribunal for Rwanda that was set up to only deal with those specific breaches of crimes against the international community. That allows for specialization and a greater familiarity of the conflict. They are aiming to be resource efficient and quick. They are in practice not really though. So let's have a look at the International Criminal Tribunal for Rwanda that was set up particularly for Rwanda only. It targeted genocide and other serious violations of humanitarian law in Rwanda. It estimated that 800,000 to 1 million Tutsis and Hutus were killed from April to July 1994. So those are the two kind of groups that were embarking in war against one another. The International Criminal Tribunal for Rwanda indicted 84 individuals, 72 completed trials, and we had 62 convictions, such as the prosecutor versus Akiyesu. I really hope I'm not butchering that, who got life imprisonment. They're currently in the process of finalizing their operations, okay? That was in 1994. So you can see what I mean about resource inefficient. It's taken them almost 20 years to, almost 30 years to finalize their operations. Okay, so kind of incredible. All right, so let's now look at, in Australia, independent statutory bodies that regulate the protection of human rights in Australia. Australian Human Rights Commission, okay? If you're asked about independent statutory authority, this is who you want to be talking about. It was established under the Australian Human Rights Commission Act 1986 Commonwealth. It monitors the compliance of Australia fulfilling human rights obligations. It provides legal advice to courts. It makes submissions to parliaments and governments regarding breaches of human rights and levels of compliance to human rights. And it initiates research into human rights and discrimination issues, such as we saw with the Bringing Them Home report, okay? They reported on the statistics and the issues related to the stolen generation. Now, this is a hallmark of a democracy. An independent statutory authority that ensures the state is complying to human rights, domestic legislation, and international obligations. If we didn't have this body, this body holds Australia accountable. If there's a human rights breach, you'll know. The AHRC will be the first one to kind of critique the human rights breach. So democracies, states that protect human rights, are states with independent statutory authorities like the AHRC. Okay, so non-government organizations. Obviously, a non-government organization is an organization that works independent from the government, okay? It has nothing to do with the government. They're an agency for reform, okay? They put pressure on the government to act and to increasingly respect human rights and, protect human rights. They help ensure greater government compliance to human rights, as I said, by investigating, documenting, and publicizing cases of human rights violations, naming and shaming, raising awareness through media campaigns, They may provide evidence to international courts and lobbying other states to apply diplomatic pressure or take action against violating states. Now, those first two are more indirect promoting of human rights, okay, indirect, and the last two are direct. What's the difference? Direct is going and doing action, whereas indirect is more naming and shaming and influencing public opinion and making the public more aware, whereas direct is getting the action. Okay, as I said, they apply moral pressure for governments to comply with and uphold human rights. They promote, not enforce. A large group of students every year always say that non-government organizations are ineffective in protecting human rights because they're really good at promoting, however, they're terrible at enforcing. Is that their aim? Are they designed to enforce human rights? No. They're designed to promote human rights. We have bodies that promote human rights and we have bodies that enforce human rights. NGOs are responsible for promoting human rights. Okay, they're not needed to enforce human rights, or they're not responsible for that. So only judge it by its aims, not by its ability to enforce human rights. You can still say that whilst they cannot enforce human rights, that is not their aim. That is not their designed purpose. Okay, in fact, I would be saying that. Okay, so we have Amnesty, UNICEF as some examples, and we have the International Committee of the Red Cross, another example. Since 1990, it has been an observer at the UN General Assembly, the International Committee of the Red Cross. Okay, so the main non-legal vehicle for naming and shaming governments and human rights abuses that happen on their watch is the media. Okay, it's the role of the media to investigate, report, and expose. The growth of 24-hour news channels and the internet means global news is more accessible for consumers and publishers than ever before. Is this necessarily a good thing, though? Is it good that we have 24-hour news, that we're kind of bombarded with all these different aspects of life, including breaches of human rights, okay? Now, the big note that I want to make here is that the media, we need to have the media for a democracy, believe it or not. We need to have things other than the government that are able to critique the government. We need to have a critique of the government, okay? Now, Sky News or Fox are usually more on the right wing, and ABC, maybe SBS, more on the left wing, okay? Now, it's good that we have both. Even if you're someone that falls more on the left wing of politics or someone that falls more right wing or more neutral, it's good that we have both. Why? Because we need to swing the pendulum. We need people with these kinds of views to critique people with these kinds of views, to critique people with those kinds of views. So we get good discussion, and so we're able to have checks and balances for each other. Because in places like North Korea, where the government is essentially running the media, no one can critique the government. If the government is doing something that's really immoral or corrupt or breaching human rights, there is no one to come out against it. Whereas if something that people who are of the Liberal Party or align themselves with the Liberal Party, they don't recognize something as an issue, Labour, the people of the Labour Party will certainly come out and swing the pendulum and say, no, we recognise that this is an issue, okay? It's good. It's actually good to have that discourse, okay? It's good to have as many different perspectives and opinions. Why? Because that's how we protect human rights. That's how we get someone saying, hold on, you're not protecting human rights. Hold on, this is a breach. Hold on, how will this affect these groups? Okay, which is really good. So this is an example of some Australian media here. Here are some example of global media companies there. Okay, so areas of effectiveness and ineffectiveness for the media. Firstly, there are less hoops to jump through to expose human rights violations, okay? There's less kind of muddle for the average person to understand human rights. The media oftentimes dumbs it down a lot, which is good because it allows us to understand it, but also can oversimplify things and not capture the full complexity of human rights issues. We also can suffer from compassion fatigue, which is when we over consume human rights breaches and really awful things happening around the world and become fatigued with how much compassion we're having to spill out. It's a platform for minority groups to voice the human rights breaches. We do have the spread of fake news and the spread of misinformation. And we have recently seen the degradation of journalistic integrity, okay? And that kind of aligns with that idea of spreading of fake news and misinformation. Okay, in 2018, the World Press Freedom Index ranked Australia at 19th globally. However, in 2019, Australia was 21st. Okay, so we've dropped down. But China sits at 177 and North Korea at 179. The media may exhibit political bias, as I said. They can be far right, neutral, far left on the political spectrum. And we have seen censorship of the media, okay, by sovereign states, such as in North Korea, as I was saying, which is prohibited under Article 19 of the UDHR. Okay, so promoting and enforcing rights in Australia. So there are 3 ways international human rights is incorporated into Australian domestic law. We have statute, common law, and the Constitution. Firstly, the Constitution was created in 1901 at Federation. The Constitution set out what Australian government was going to look like and how we would operate as a newly federated sovereign nation state. It introduced 2 fundamental concepts, the division of powers and the separation of powers. Now, the division of powers basically separated federal, state, and local councils and the different areas of law that they oversee and are responsible for, okay? This was good because it frees up the time of the federal government, so the federal government doesn't have to overlook everything, even things like, bin collection. That's more the responsibility of local council. So then federal governments can refer to and look at more important things like taxation, like immigration, those kinds of things. It also ensures considered and more effective responses to the needs of the unique locality. Okay, maybe we need certain roads to be fixed in certain suburbs, and that will be, you'll need to really listen to the local residents there, whereas the federal government may not be as in touch or aware of these issues. Okay, the separation of powers is our strongest defense to efforts made inside the government to take and control and degrade human rights or civil liberties in Australia. Okay, why? Because the legislature, right, which is the parliament, judiciary is obviously judges, common law, the executive are the ones that enforce the law, so the police, the military, the army, those kinds of groups. Let's say the legislature, the parliament, makes a really terrible piece of legislation and passes it, enacts it, that allows people to breach each other's human rights. The judiciary can come out and say, hold on a second, no, that's not right. We need to fix that, okay? And kind of critique the legislature because it's separate. It's a separate body. Whereas if they're together, they're kind of going to agree on the same thing. So if they mutually make kind of a really bad decision, or they pass a bad law or pass down a bad precedent, there's no one that's going to critique it. Okay, so having the separation of the powers allows the judge to come out and critique parliament to critique judiciary, police to critique judge. You can see how it's going. Okay, this is the main principle of democracy. It's really, really important. Okay, the Constitution also contains 3 express protections for human rights. So the right to trial by jury, freedom of religion, and the right to property. That right to property basically says that the government can't just knock on your door and take your land and just say, all right, you have to go live somewhere else now. Freedom of religion is that you can practice any religion that you would like without prosecution or persecution, and the right to trial by jury. Okay, those are the express rights. The Constitution literally states that you have those rights. The High Court has also found that implied rights exist in the Constitution. Okay, implied rights are not express rights, they're not written, but they're implied, they can be inferred. So the right to vote is an implied right. Freedom of political communication also is an implied right. Statute law now, moving on from the Constitution and how that protects human rights. Statute law also protects human rights by literally defining the human rights and saying that they cannot be breached, okay? Things like the Anti-Discrimination Act 1977 and the Australian Human Rights Commission Act 1986. Common law now. Common law is really important because it applies statute law to the unique circumstances of cases, okay? So let's say the Commonwealth Criminal Code, all it said was that slavery is someone in shackles who cannot eat or drink and is living in a dungeon, okay? Really random, but let's say that was the definition. In R versus Wei Tang, the judge would have had to apply that and said, all right, is that the definition of slavery in this case? Is this still slavery? And applied the statute law to the unique circumstances of R versus Wei Tang. Obviously, it was not what in that made up law that I just made, it was not that. So the judge would have had to kind of create new precedent about slavery. Now, that obviously isn't what the Commonwealth Criminal Code says, but I'm just saying, I'm trying to demonstrate that common law applies the principles of statutory law to the unique circumstances of case law, okay? And that's its biggest benefit, because statute law is usually very vague and ambiguous. Common law obviously has really specific nuances and intricacies and specifics for each case, where someone needs to kind of think, is this a breach of human rights? So it fills in the gaps that statutes don't cover. Things like the presumption of innocence, the right to a fair trial, and native title. It evolves independent from government and parliament, as I mentioned with the separation of powers, and it frequently draws from authoritative international documents, okay? For example, Justice Brennan remarked that international law was a legitimate and important influence on the common law, especially when international law declared the existence of universal human rights. Okay, so international law directly influences the decisions made in common law. Common law is also not fixed and can be rendered redundant by later statute. Okay, so statute legislation can override precedent as well. Okay, courts and tribunals now. We have the Australian Human Rights Commission. We mentioned the Australian Human Rights Commission. They're considered an independent authority that promotes and enforces human rights in Australia. We have the High Court, which sets precedents which are binding and final on all other courts. They overturn legislation that is unconstitutional. We have Roach v. Electoral Commissioner 2007 that upheld that all people, regardless of circumstance, have a right to vote. Justices do sometimes consider international documents or conventions where there is an absence in the domestic law. We also have Lange versus ABC 1997, which is a case where we saw the effectiveness of the media. So the ABC released a Four Corners episodes alleging corruption and bribery by the then New Zealand PM David Lange. Lange commenced defamation proceedings against the ABC, but the High Court said an implied freedom of political communication must exist in a society that is built upon democracy. So the media is able to critique the government. Lange just can't come out and say, I don't like this kind of defaming, these defaming accusations if he's a political figure. Okay, so a Charter of Rights. So a Charter or Bill of Rights is a highly significant document that enshrines a sovereign nation's human rights in law. Okay, basically outlines the human rights of a particular state. Several Western countries have a Bill of Rights, like the US, the UK, and New Zealand. However, Australia does not have a Charter of Rights. Okay, Charter of Rights of sorts exists in some jurisdictions, but we don't have a national federal Charter of Rights. Now, I'm not going to go through all of these, but you do need to know arguments for and against having a Charter of Rights. I've seen plenty of questions asked about it. So, arguments for a Charter of Rights, well, we have high community support of a Charter of Rights. It protects the marginalized and disadvantaged. it could improve the quality and accountability of the government, or because it enhances accessibility. Okay. For the average person, understanding all of their human rights in Australia is a bit tricky because they have to go to the Constitution, then statute, then common law. Whereas a Charter of Rights basically simplifies it and says, these are all your rights. Arguments against having a Charter of Rights, though, basically, we don't really need it. There is nothing that pressing happening to the Australian people at the moment that really is calling upon us having a Charter of Rights. It also undermines tradition of parliamentary sovereignty, okay, in that the parliament makes statute about human rights, and that they don't need a Charter of Rights. Yeah, this idea of if it ain't broke, don't fix it. We don't really need it. All right,